Well, good afternoon. Good afternoon and welcome to another Webinar Wednesday hosted by the Cal State Bakersfield Small Business Development Center. This is episode number 287. Thank you for joining us. It's great to be here. I'm Kelly Bearden, the director of the center, and I will be your host for today. But what's up today? August the 16th, 2023. Well, you're going to learn why intellectual property is such a great business strategy. And we will have our experts in from the United States Patent and Trademark Office talking about that in just a little bit. We'll get a little bit of economic sense from our resident economist, Dr. Mark Evans, find out what's going on macro-wise in the economy and a lot of the things, crazy economic times. And Dr. Evans will get us some economic sense in that particular area. We'll talk about the City of Bakersfield grant program. They are taking applications. The applications are coming in. Those are accepted on a first come, first served basis. Capital Quarter is getting preempted. So Capital Quarter is on next week. And we are preempting Capital Quarter just because we just have a lot of content to go through in a short amount of time. Our community calendar, we'll talk about how it's heating up, kind of like the afternoon temperatures here in the San Joaquin Valley. So we'll talk a little bit about the community calendar and a lot of things going on. Your questions can go in the Q&A box, and we will take those at the end of the webinar. Our executive producer for today's webinar Wednesday, Maureen Busher-Dang, will be working the chat box and putting resources that we discussed today in the chat box for you. And today we will have a topical poll. So let's jump into what we're calling a topical, not a tropical, but a topical poll. So our first poll question is going to go back to during the pandemic, over 22,000 California small businesses were surveyed. And what was learned when we talked to 22,000 small businesses throughout the state of California, maybe some of you participated in this as well. So what we're going to look for is with our first poll question is what percentage of the small business implemented some type of innovation during COVID? Was it 19%, 49%, or 70%? Now, in looking at innovation, these innovations, isn't necessarily bringing in an intellectual property. It's some of the changes and some of the differences that could have been made during COVID-19. So what were those particular changes that were being implemented during COVID-19? And how many small businesses did it? 19%, 49%, or 70%? So we'll give you another moment or two, and we are going to close the poll. We do have 64% participating, and we are going to end the particular poll. And last chance to get in, and we'll end the poll. 71% of you participating, and share the results, and 60% of you say 70%, which is correct. And those innovations could have been anything from curbside development or adding e-commerce, a lot of different ways small businesses innovated when we were faced with the pandemic. So 60% of you had 70%, 20% 49%, and 20% 19%. So thank you for participating in poll question number 1. Let's go to poll question number 2. And poll question number 2 is going to be, of those who responded to the survey, who were most likely to innovate? Was it younger firms less than 5 years old? Was it businesses that had been around 6 to 15 years, or those older than 16 years? So most likely to innovate, was it done by younger firms, firms that had been around 6 to 15 years, or firms that were 16 years and older? So up to 46% of you that have participated in this particular poll. When, me, I like to hit that 60% threshold. Hit that 60% threshold, we will end the poll and actually share the results with you. So last chance to get into this particular poll. And we do have now 66% of you participating and sharing the results. We have 50% of you saying 5 years or under. And that is correct. The young firms work quickly and more likely to innovate during the pandemic. So half of you got that particular poll question correctly. And let's move on to question number 3. So getting back to the survey of 22,000 small businesses, what drove a high degree of the innovation and adaptation that happened? So what we're looking for is, and maybe having a little bit of problems with this particular poll. Let's try it again. Try to launch this poll again, and it is not going to launch. So our last question dealt with what drove that innovation. Was it going to be desire? Was it going to be necessity? Or was it Webinar Wednesday that drove that? And of course, the correct answer, everybody gets this one right, is going to be necessity drove the innovation. I think we might find that is a common theme with what happens with innovation. So thank you for participating, and let's move along. We have an economist in the house, Dr. Mark Evans, 40 plus years of California State University, Bakersfield, much of that as a professor of economics, now an emeritus professor of economics when he doesn't go by his role of resident economist for Webinar Wednesday. Vast number of experience, a lot of fun things and topics to talk about. Dr. Evans, take it away.
All right. Thanks for joining us today. I thought what I would do is provide a macroeconomic update. Those of you that have been away from school for a while, macroeconomics means inflation and unemployment. As we've mentioned in the past and has been in the news, what the Federal Reserve is trying to do is execute what's called a soft landing. And basically what a soft landing would be is a situation where they successfully lower the average long-run inflation rate back to 2 to 2.5% or so without inducing a recession along the way. And as we've mentioned previously, what that entails is increasing interest rates, tightening credit for the purpose of slowing GDP growth, let's say probably to somewhere less than 1.5% or so. So in other words, if the economy is still growing from 0 to 1.5%, we've avoided a recession. And what this would do is a very low rate of growth would take some heat off of the labor markets. So the idea is if the slow growth could maybe inch the unemployment rate up to the low 4s or so, 4.1, 4.2%, somewhere in there, 4.4, let's say 4.5. What that would do is taking the heat off of the labor market would reduce wage growth to 3.5%. And then with 1% productivity growth and labor force growth on average, this would bring the inflation rate back down to 2.5% or so. So that's what the Fed is trying to do. And what we're trying to do in Webinar Wednesday is sandwich between FOMC monetary policy meetings, a session where we talk a little bit about what the Fed just did, and then what data's come out since their last decision, and then look forward a little bit in terms of what we could expect between then and the next meeting. And so, for example, there was 2 very close meetings together in June and July. And then after the first meeting in June, we talked about it and anticipated a little bit on a Webinar Wednesday. And today what we're going to do is talk about what the Fed did at its latest meeting in July, and then what we can anticipate for the remaining meetings this year. There's one in September, and then there's one in November and one in December. So here's where we've been. As you may recall, in the June meeting, the Fed did nothing. They did not, they paused further increases in the federal funds rate, but they did announce that there would most likely be 2 quarter-point increases by the end of the year. And the reason is that the labor market was still overheated. At that point in time, the unemployment rate was 3.7%. There were about 1.6 job openings for every unemployed worker. And then secondly, the personal consumption expenditures core inflation rate, and that's the rate that the Fed tracks, was still running around 4.5% or so instead of the 2.5%. An interesting thing that happened at the June meetings is they did update their 2023 projections for the year. And on the next slide, I'm going to show you how their projections have changed over time and what the economy's actually done. And I think what we're going to be able to infer from that is the Fed expected the economy to slow a lot quicker than it has. There's considerably more momentum than they thought. So, okay, for the June meeting, they released a forecast where they projected that from fourth quarter 2022 to fourth quarter 2023, the economy would grow by only 0.4%. So again, less than that 1.5. This would inch the unemployment rate up to 4.5% by the end of the year, and that would reduce the core inflation rate from about 4.5% to 3.6%. So this is this was their forecast, and I would say this was their intent. Basically, what they were telling us is what they're going to try to do is slow the economy so that by the end of the year, what we look back, what we would see is, no more than 0.5% GDP growth, an unemployment rate about a point higher, and a decrease in the inflation rate. Okay. For the recent June meeting, their forecast for 2023 was now, instead of a 0.5% growth, 1% growth. Instead of the unemployment rate rising to 4.5, they were now projecting 4.1. And they said, gee, we're not doing quite as well in terms of core inflation as we thought. We think that for the year as a whole, it's going to be 3.9, where they previously thought 3.6. Now, let's look at the actuals. The actuals are through the first half of 2023, the economy is growing not below 1.5% or so, but 2.2%. The unemployment rate, rather than going from 3.7 when they initially looked at it in June, going up to 4.1, it's now gone from 3.7 to 3.6 to 3.5%. So the labor market remains really overheated, and we've seen no progress at all in terms of the core inflation rate. It started out around 4.5, rather than ratcheting down to 3.6 or 3.9. It's still running at 4.4% a year. What they're doing is monitoring what's going on since the July meeting. Here's the stuff that's already come out that's I think most likely to influence their decision about what they do in the September meeting. Second quarter GDP was announced as 2.4%, well above everyone's expectations. So the economy is growing much more rapidly than people thought. Labor markets, there is some slowing, which is a good sign. Okay, the JOLTS survey, or job openings and labor turnover, there were fewer openings, unchanged in May and June at about 9.6 million a month. That's the lowest since April 2021, but it's still very high historically. New hires has gone from 6.2 million in May to 5.9 in June. So again, some slowing. The quit rate has decreased from 2.6% in May to 2.4% in June. Labor market is beginning to slow. In terms of job creation, it's averaged 280,000 a month throughout 2023, which is a really large number. But it's gone from, both in June and July are below that monthly average. And in July, it's 187. the Fed would probably like to see something like 125 to 150 a month, somewhere in there. So we're still, again, it's going down, but it's still a very strong pace. The unemployment rate came out since the last meeting, and there was a further decrease. It's now just 3.5%. Average hourly earnings came out since the last meeting. It's still running pretty strong at 4.4% annual. The good news is that in terms of labor force participation, the female labor force participation rate in the prime age groups, 25 to 54, is now almost 0.5% above where it was pre-pandemic. The male rate took longer to recover, but it has now reached the pre-pandemic level. So that's good, but there's really very limited capacity for the labor force to increase further. It's pretty much running at historical highs now, especially with childcare issues. Upcoming data that the Fed's going to be looking most closely at will be end of the month, basically the 29th. This job openings and labor turnover survey. August 30th, the revisions to second quarter GDP. The 31st, the price index that they most closely follow. September 1st, the employment report, which also provides some wage information for August, but the index that's actually better than this wage data for tracking cost pressures on inflation will not be out until after the September meeting. With that, I think the Fed's basically waiting and seeing. My guess is that we will get another quarter point bump in September or November. If I had to guess, I'd probably say they're going to pause till November, and if there's a third one coming, they would stick to their previous announcement that it would be 2 in 2023, and we'd see it in early 2024.
Well, thank you, Doctor. That's fascinating that, they keep trying to slow this economy down and they can't. And I guess that's a good thing. Okay, so quickly coming up with some information, the city of Bakersfield has their loan program, their grant program, actually, that's open for 163 businesses to receive $5,000 to $10,000. Various rules and eligibility requirements. You have to be in a qualified census tract or lower income area. Go to a class and actually do a business plan and talk to a consultant. Also, some of the other basic provisions. Really, kind of the easy way to do this process would be to actually meet with one of our SBDC advisors. There is our website to where you can join and actually request services, where you can actually then determine your eligibility and complete those necessary steps. Moving on to the disaster front, there was a disaster declaration that was extended. We'll talk a lot about this next week. So if you're interested in the disaster, there's some information we can send you, and there'll be some that will be included in our actual send out of information with a later email with the recording of this and also some of the resources that are available. Capital Quarter returns next week as we continue looking at the debt ceiling for small business. We'll have number 7 of the factors that can limit you from raising capital. Our community calendar, we do have a lot of events coming up, including the Hispanic Business Conference and Expo on the 30th of August. If you're looking at a training program and you're in the food business, an outstanding one is offered by Cal State Bakersfield through the Extended Education, the Bakersfield Food Management Program. Contact us or contact them. Native American Summit, Economic Summit is coming up. So that will be also on October the 30th, a popular day here in the Southern San Joaquin Valley. And that will be held in Porterville. Also, the city of Bakersfield has a business security improvement grant program to help add security features to your business establishment. More information on that. So there is some of the benefits of the IDLE that we talk about. Also, some human resources. The human resource hotline there's your 800 number if you need answers for California labor law, any questions that you might have. All these webinars are hosted on our CSUB YouTube channel. Feel free to subscribe and actually find out. Maureen pops a new one in here at that time. So that brings us to our special guest today. Excited to have back the United States Patent and Trademark Office. We just call them USPTO. Brent Fairbanks joins us today. He's a primary patent examiner and assistant outreach coordinator. He has a focus on data processing of sensor measurements, where the sensor systems include seismic exploration, motion tracking, device location, serves as the assistant outreach for the entire Western Regional Office, works a lot with K through 12. He has his Bachelor of Science in Electrical Engineering from Cornell. That's kind of a big school. And also the USPTO in 2016 after actually being in the software and actually semiconductor industry. So Brent, welcome. It's great to have you here. Great topic. We're excited to have USPTO back. Go ahead, take it away.
Thank you. Let me get my slides on screen. So I feel a little bit embarrassed, getting to hear my whole resume read out there.
Well, that's what we're here to do.
Okay. So am I sharing successfully?
Not yet. Let me go ahead and stop, and maybe that'll make it easier.
There. No, that should do it.
Got it.
Okay. So as been introduced, I'm Brent Fairbanks, Assistant Outreach Coordinator for the Silicon Valley office. I'm actually here in San Jose right now. So not quite as warm as where you are. I want to know that this is for informational purposes only. It's not legal advice. I'm not a lawyer. Please consult with appropriate sources for legal authority and guidance. So I'm here to talk about all forms of intellectual property, which goes all the way back to the Constitution. So in the 1790, what was that one? They wrote that the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. What we have found is that over the past couple of hundred years, this has a major impact on companies economically. A study that was done a few years ago indicates that companies that have an intensive focus on IP have about $1,500 a week different. I'm sorry, the numbers here: $1,500 a week as opposed to $950 a week for companies that are less IP intensive. More of their employees are full-time, have health coverage, and tend to be college graduates than in companies that are not in the IP space. The numbers in that study indicated that 63 million jobs, almost 44% of all jobs in the United States, were in companies that had a large amount of IP. Overall, that was producing half of the gross domestic product of the country, to a total of $7.8 trillion. As said before, wages tend to be higher, and benefits tend to be higher if you've got an intellectual property focus. So there are many benefits to intellectual property. If you've got a business that's got it, you tend to be attractive to investors, or if you're trying to sell your business, to buyers. If you've got intellectual property, you have protection against infringement lawsuits. You have now a property right that adds value to your company. And going back to investments and buyers, if you want to, on the other side, be doing a merger or acquiring another company, you've got some increase in your amount of leverage and power. So what is intellectual property? oops. Everyone understands what real property is. You know, you own a house, you own a car, it's something tangible that is yours that you have the deed to. Intellectual property is intangible. That's creations of the mind, something that you have come up with through your own ideas, your own hard work, your blood, sweat, and tears, turning something that you thought about into a real product. So in the house example, we've got a nice white picket fence that defines the boundary of where my property line starts. For intellectual property, we have to define some sort of a legal construct that surrounds the idea, the concept that you've come up with. And those come in one of 4 forms. The first of the 4 is a patent. That's my daily work. And it covers some new and inventive idea, generally about a product or a way of making a product. Then we have trademarks, which are what you would associate with a brand because it identifies where a good or a service comes from. The next type are copyrights, which cover creative expressions, things like songs, books, printed publications. And then finally, we consider trade secrets to be a type of intellectual property. And trade secrets are interesting because it's something that you don't know about. Unless you're inside the company, in theory, you shouldn't know that the trade secret exists. And that's how you control this piece of property you've got. The famous example here is the Colonel's 11 secret herbs and spices. So if you are interested in pursuing a business that has intellectual property as a strategy, the first thing you should do is take a look at what you've got and make a list, prioritize. What is the most important thing to do? Part of that is knowing what your competition is. Where are they going? What kind of a space have they carved out? How do you compete with each other? The third question to ask is, how fast is your industry innovating? Is it fast growing where things are changing quickly? Is it slow growing where things change more methodically? Then with that in mind, hopefully you can determine the best way to protect your intellectual property, then develop a plan, set up some goals, and start implementing it. And finally, get help. We've got a bunch of resources, which I will go to at the end of the presentation after I talk some more in more detail about the different types of IP. So the easiest one to talk about is a trade secret. As I discussed before, trade secret is something that ideally no one outside of the company knows about. It's important to know that the US Patent and Trademark Office does not review trade secrets. It doesn't regulate trade secrets. We don't know what they are. That's entirely within the company. On my slide, I've got the Colonel's chicken recipe, which has never been disclosed. As far as we know, Google doesn't tell anybody how their search algorithms work. Another example is your Apple iPhone. There's a lot of things going on in there that are not going to be disclosed by Apple in any way, shape, or form. And they control their trade secrets in order to prevent them from coming out and being used. If you have some sort of formulas, programs, techniques, or processes that are critical to your business, you might want to consider just keeping those secret. Trade secrets protect commercially valuable proprietary information. As I said before, formulas or business information that is giving your company a competitive advantage compared to your competitors. They're not known, and if you want them to continue to be not known, then you need to take action in order to preserve the confidentiality. There have been a number of lawsuits over the years with employees that left the company, took a trade secret with them, and either tried to start another company or join a competitor. Trade secrets could also be lost via reverse engineering, or somebody just coming up with the idea on their own, which, if those are concerns that you have, then you might want to be looking at a patent. So moving on to the next type, we have copyrights. As I said before, copyrights are going to protect in creations, things like songs, works of music, books that have been written by an author. Copyrights cover movies, and I had not known this until I started this position, but they also do sculptures. The US Patent and Trademark Office does not handle copyright. That's done by the Library of Congress. They have a website here, copyright.gov, that you can access in order to get more information about it. And a copyright will protect original works of authorship. As I said before, it could be literary, dramatic, musical, artistic. And you have a protection that lasts for your life or the life of the person that created the material, plus 70 years. Next is trademarks. Trademarks is any word, any name, a symbol that identifies where goods or services come from. I'm sure that most everybody recognizes the golden arches from McDonald's. And because they've got a trademark on that, and they spent a lot of time and effort promoting that trademark, I can't drive down the freeway without my children noticing the golden arches and wanting to go get a hamburger. They know exactly what to expect and what comes from there. Some other examples I've got on this are the Girl Scouts or Apple Computer, or as I like to find out if the junior high or high schoolers will recognize Air Jordans, which they always do. Trademarks come in 3 types, which I'll discuss in more detail later, but you'll see either trademark, service mark, or registered trademark on different slogans, company names, etc. Research has been done in 2022, tried to put a value on companies, their entire brand profile, part of which is the trademark. And the total amount of goodwill and recognition that this researcher estimated had been built up around Apple was a total of almost $500 billion. Microsoft was about half of that, as was Amazon and Google. But these are substantial amounts of built up brand value. And this is based on the trademark protection plus all of the work that companies have done since they were incorporated in order to build up their brands. So I said before that there's 3 different types of trademarks. The basic one is called a common law trademark. That's for something that is used in commerce, but it's not registered. If I open up a business, I give it some sort of a name, I can file with the state of California to have a trademark. That is only good within the state of California. I don't even have to file. I mean, I can start a business locally, give it a name, and if I put TM symbol on there, then I have some amount of protection. However, there's nothing at all to prevent somebody in a different part of the state from opening a business with the same name. Also, there's nothing to prevent somebody from in a different state from opening a business with the same name. Which today with the internet becomes a problem, because I could very quickly be trying to sell stuff across the country, if not globally, just using the website. It's important to note that in the United States, the first person to use a set of words or a symbol can get the trademark. As opposed to internationally, it's the first person to actually ask for it. So if you're going to be doing business across the country, it's probably a good idea to get a federal registration. This puts a notice that you have an ownership for this particular word, for this particular symbol. It gives you a presumption that you own it and you have the exclusive right to use. You can defend it in federal court. And there's a little circle R symbol that you'll see on a lot of products. You'll be listed in our online databases, and also recorded with Customs and Border Protection in order for you to allow infringing foreign goods that might be using your trademark to try and sell their stuff from coming into the country. Trademarks can be words, they can be designs. We're all familiar with Starbucks and Nike and Target. You can trademark a color. For example, that particular shade of brown is trademarked by UPS, as is the green-yellow pattern that John Deere uses. You can trademark scents. I had not known this, but Verizon stores have a particular smell when you go into them that's trademarked, as does the Play-Doh that the kids play with. You can trademark sounds. The particular pattern of notes that you hear on NBC is trademarked. And then there's a concept of trade dress, which is somewhat of the look and feel in general. All Doc Martens kind of look like this. Hershey's Kisses look like this. All the Apple stores have a particular look that the respective companies have covered under the trade dress provisions. So now turning to patents. A patent is a property right that the United States government grants to an inventor. It allows the inventor to exclude people, to exclude others, not just people, companies, from making, using, offering for sale, or selling the invention throughout the United States. Also from bringing it into the United States from overseas. So it's an exchange. We ask the inventor to disclose how you did it in enough detail that somebody else can follow along in exchange for a limited time of being able to be the only person that can do it and to exclude other people from doing the same thing. There are three types of patents. The first one is utility, which I see the most of. That covers tangible things, new and useful process, machine, article of manufacture, or composition of matter. I'm always asked about computer software, and the high-level answer to that is software is covered as a utility patent as long as it's somehow associated with a real thing and is having an impact on a machine or a manufacturing process or something. I can talk, if you've got questions, I can talk more later. A design patent covers an original ornamental design. The example I have here is a Statue of Liberty is covered by a design patent. The shape of a lot of cars or particular components within a car will be covered by design patents. And then finally, there are plant patents, which cover plants that are asexually reproduced. These are things like potatoes or garlic, a bunch of flowers. If you work on them and come up with a new version of flower, say, you can patent that as a plant. I did an analysis a few months ago and looked at what do people in California get inventions or get patents on. And actually, there wasn't very big surprise here. A lot of it is data processing over on the left, sending communication around via cell phone, internet, whatever, is the big blob there next to it. We have some medical devices is a big chunk, and then we start going into more specifics of wireless networks, televisions, etc. No, as I said, there's not a lot of surprise here. If you look at where they are in the three types of patents, the vast majority are covered by what we call utility patents, which I described before. Like, what is that? Less than 7% are design patents, and then there's a very small number of plant patents across the state. So we believe that a patent system benefits the public by ensuring that people that invest time and money get a reward. You put your time, your effort, you invest your own money to come up with this idea, file with the US Patent and Trademark Office. We grant you a patent, and now you've got 20 years that you can monetize the work that you put into this in the first place. It does require publishing it so that the public knows how you did it. The theory here is that by publishing it and people then reading what you published, they might have a new aha moment, come up with a new idea, and go off in another direction and create something that's valuable also. And that this whole process feeds back on itself, and it accelerates the rate at which new ideas come up, new products come out, and builds up the economy overall. If you have an idea, you want to file it as soon as possible, practically. In the United States, our law is that the first person to get to the patent office with an idea gets the patent. If you are wanting protection only in the United States, you can make some sort of a public disclosure as long as you file within a year. However, if you want to get protection in other countries, if you're planning to sell in Europe or Japan or China, you have to file before you tell anybody anything, because of the way their law is structured. So talking too early, for example, taking your invention to a trade show and wandering around the booths and trying to drum up some interest from investors or potential clients is a problem, because this is creating a public disclosure. And if you don't get your patent into the system within a year of that date, then you're not able to actually acquire a patent for what you have. You need to be very, very careful about going to GoFundMe or that's not the one I wanted to say, Kickstarter, or another crowdfunding site, because we see people, they put up an idea on Kickstarter, they show their idea then virtually to a large number of people, and create a public disclosure event. And you might think it's a good idea to write it up in a news article or your blog to put it on the internet. Again, this creates a problem with public disclosure. So once you have a patent, the responsibility is you in order to actually enforce that. There's no organization out there that's going to be watching the marketplace to see if somebody else is infringing on what you've got. You need to do it. When you find something that you think is infringing, you can go to Customs and Border Protection. You can go to stopfakes.gov, and the Department of Commerce will help you to do the enforcement in those situations. So I wanted to go through some of the resources that we have available. First off, there's a bunch of us. There's over 8,500 patent examiners. The agency has 13,000 people total. Over the course of last year, we saw almost 650,000 applications come in, and we issued 361,000 patents. On the trademark side, it was well over 500,000 applications that came in, and over 1/3 certificates of registration. The office has a bunch of free services. at the URL below, uspto.gov/free services. Look for these particular logos to guide to where you want to be in particular. And if you're not sure where you want to be, if you've got you're starting a business, you don't know, do I want a trade secret? Do I want a patent? Do I want a trademark? We built a tool at ipidentifier.uspto.gov that asks you a series of questions. Based on how you answer, it makes suggestions about what type of protection you want, and then offers you up links to go to the appropriate places in order to pursue further. Recently, and this one's brand new, we have announced the first-time filer expedited examination pilot program. I really hope somebody comes up with an acronym for that. What this does is normally a patent application comes in, it waits for 12 months to 18 months before an examiner looks at it. If you're a small inventor, a solo person working from home, or maybe there's a couple of you, you can file in this program to jump to the front of the line. There's a lot of details on this slide and the next. It's basically encouraging inventors that are new to the process. It's free. And it gets you to the desk of someone like me faster than if you came in otherwise. Go to this link here below for more details, and hopefully we can put that in the chat. The office is split up into 5 regions, becoming 6. I work out of, or used to work out of, the San Jose office over on the West Coast. We also have regional offices in Denver, Dallas, and Detroit. And there is an office that will be open someplace in the southeast part of the country as well. We have an Inventors Assistance Center, pro bono programs, and I will talk about those next. The Inventors Assistance Center is staffed by former supervisors and people like me that can answer questions about how patents are examined, what the process is. It's staffed 8 to 8 Eastern time, and you can just call up and ask questions. We have a nationwide network of attorneys that have offered to provide services to small businesses, to people by themselves that have not come into the process before. And you can go to that link as well. They're split up across the country. California is covered by the California Lawyers for the Arts.org /CIAP for the California Inventor Assistance Program. There's also a various number of law schools that have students that are studying patent law that will work with small inventors in order to draft applications under the guidance of a faculty member that's watching what they do. And they offer this as I believe, either a free or a low-cost service based on the school. We have a nationwide network of resource centers. There's one in Sacramento at the State Library. There's one at the Martin Luther King Library in San Jose. Also one in Riverside and in Los Angeles. Oh, and San Diego as well. Those offer a bunch of resources, a physical presence. Of course, in these days, probably everyone is online anyway. Finally, we've got a lot of programs going on. This is just what's coming up this next week or 2. We have a series of talks on how to get to a patent called Path to a Patent. The next one is coming up on Thursday. There's a series on how to get trademarks called the Trademark Basics Boot Camp. There's one I'd actually like to sit in on, how to think like a patent examiner. And then next week, there's classes both on patent and trademark basics. Go to our website /events to get this complete calendar, and it goes and goes. There's a lot more. So with that, I'd like to say thank you and open up the floor for questions and answers.
Well, fantastic, Brent. Just a tremendous amount of resources that you have at USPTO and events, and boy, just tons of stuff. So great information to process. And let's go to we have a question. Let's go to that question. What happens if in the US, what happens in the US if someone else files during the first year of disclosure?
That is an excellent question. And that is why it's better not to disclose. If someone has filed a patent has filed an application for a patent before you actually did, now you're in the unenviable position of having to prove to someone like me that you did have the idea first, and coming up with proof that you had the idea before the other person had actually filed in the first place. It gets difficult. It can be time consuming. So your best protection is to file before you start talking to people.
So next question is the events that you shared, tremendous amount of events coming up in August of 2023. Are those events listed by Brent recorded or to be viewed at a later time?
I know that the Path to the Patent series is not recorded. We have concerns that I say something wrong and then it becomes public record if it's recorded. There probably are other concerns on that. I would have to look at the other classes to know exactly whether they're recorded or not.
So the best way would be to go to your USPTO website and check.
Exactly. So if you go to the uspto.gov/events and start clicking through into the different classes, they should disclose whether or not the recordings will be available.
And Brent, you're way too modest. You'd never say anything wrong.
I'm sorry?
I said you're way too modest. You'd never say anything wrong.
Oh, could you say that while my wife is in the room, please?
I had to draw the line somewhere. Sorry. Okay, we have a follow-up question. What happens if you file a provisional patent and then add to the final patent?
Generally, we want to see, and I didn't get into the details of provisional versus non-provisional. So a provisional patent should have all of the information necessary to support the legal description of the protection you want to have when you actually file the non-provisional application. If you miss some stuff out, the question then becomes whether that's important to support what you're asking for in terms of protection. If you've missed something that's important, then that's going to cause your the date that you asked for protection to move forward in time. And if someone then had snuck in between when you filed your provisional and you filed your non-provisional, that becomes a problem.
And just to add to that, provisionals are just applications, so they can never germinate or become a patent itself. So you eventually would have to, within the first year of submitting a provisional application, you would have to submit a non-provisional application, which is the application that the patent examiner actually examines and could hopefully germinate into a issued patent. I think there was a similar question in the chat about provisionals.
Yeah, and thank you. That's Ken Takeda from USPTO. Just goes, maybe Ken can tell that to Brent's wife. Okay, so hitting the chat real quick as we're running up against the hour, we see a lot of information in here on some of the programs that we got started. I mean, you're searching for a particular question that might be, but there's the Central Valley Native Economic Summit as far as, and a lot of other things. There's programs that where you can access and find it at USPTO as far as outreach. Copy of the presentation. Is that available? I know we'll have a copy of the recording that is sent out to everybody who signs up, along with a list of a lot of these resources that I just mentioned. But do you have the slides somewhere?
I could generate a PDF of the slides and forward them to you to distribute.
We will include those in the resources that are emailed out later this week.
Okay.
And then there's a question, is there a way to see the path to a patent series from the beginning? I think it's
as I said, we don't put up recordings of the actual talk. You could email Silicon Valley at uspto.gov and ask for a copy of the PDFs that we have presented in this series. Alternatively, we restart the series every quarter. So we will be beginning it once again in October.
Okay, well, just a tremendous amount of resources available on your website. And I know you guys were active earlier today with other meetings and webinars, and you doubled up on us. You know, I try to double up on everybody by bringing in my economist, and we get both Ian Pagata and Brent Fairbanks from USPTO. Thank you, gentlemen, for joining us. Plenty of information there, great resources, and that is going to wrap it up for this week. So thank you, and let's see some of those inventions and patents make their way to San Jose, because do you know a way to San Jose, patents and trademarks? I think so. So that's
Thank you for having us.
Thank you, and it's a pleasure as always getting that information. That'll do webinar number 287. We'll be back next week. Everybody have a great week, and we'll see you then. Bye-bye, everybody.